Welcome back. You are watching The Front Row. Thank you for staying with us. The hashtag we're using on our social media platforms is The Front Row, and I'll be taking a look at a number of your views. But just before we delve into the deeper issues around this and the legal battles that the executive continues to lose, I want us to quickly go back to some of the critical decisions that have been made by the court that have painted the government in very bad light and going ahead to trigger very serious scrutiny on the role of the Attorney General. So let's then just begin with the latest, and that's the Huduma number that we've been talking about with my panelists here. That decision that was taken last week on Thursday, and the court ruled that this particular process conflicted with the Data Protection Act of 2019. Then just a month before that, the appointment of the Nairobi Metropolitan Service Director General, General Mohammed Badi, into cabinet meetings was quashed, and the ruling was that General Badi has been prohibited from attending any cabinet meetings or taking up any functions of the cabinet. Well, again in August, the Court of Appeal declared the BBI null and void, agreeing with the decision that was taken by the High Court in May of the same year, this year. The BBI process was termed as unconstitutional, and this process is what brought about a lot of issues and was the nerve center of this conversation, or this case of the Building Bridges initiative that sought to change the Constitution. So then in June, President Uhuru Kenyatta's Executive Order number 1 of 2020 was again quashed and termed as unconstitutional. Among the key things in this particular executive order was placing sections of the judiciary, tribunals, commissions, and independent officers under the executive, and the court ordered that then it is meddling with the independence of these particular institutions. Then in May, the appointment of 129 board members and parastatal heads was again quashed, as their appointments was termed as illegal, lacking transparency and competitiveness. In May again of this year, what I mentioned, the High Court declaring BBI as illegal and unconstitutional. And in April, the High Court declaring the position of Chief Administrative Secretary as unconstitutional. This was what the President came up with in his second term, and many had seen it as a way to reward political friends and CSs who continued to serve without being vetted after the 2017 general election were declared. This was declared that they were in office illegally again. The concept of lack of competitiveness and transparency around this, that they were not vetted afresh, and the position was created without public participation and engagement. This is just some of the critical cases that the government has lost just this year. We haven't even gone back to some of the cases that were lost in the previous years. And Martin, looking at some of these cases, and you'd already touched on the issue of process, most of these cases the government has lost because of either failing in the issue of process, failing in the issue of public participation and engagement. What does this speak to? Is it lack of counsel, lack of good counsel, just blatant disobedience of the law? What is it?
I think that I don't think that the government goes out of its way to break the law or to behave unconstitutionally. It's just that the cheese has moved, and the mouse here does not seem to know what has happened to it. So that when this change in the constitution happened, what the government should have done is to sit back and ask the question, how have we behaved in the past, and what needs to change in light of the new constitution? When you ask that question, then you make it necessary to keep checking your actions against constitutional provisions, so that it becomes a technical and a legislative process where every time government is taking an action, it is cited of possible constitutional barriers or provisions to meet, so that if the process has been tested against the constitution, that boxes have been ticked, then you can proceed with the action. The problem is that that kind of auditing hasn't happened. That kind of preparatory nature has not come into question. There is denial, obviously, on the part of government that, look, the judiciary is against us, or they are not understanding we need to run government, they must listen to us. That's okay. The executive has to run business. But so is the executive supposed to understand that the judiciary is now emboldened. The judiciary has new instruments in the name of the Constitution, and it has to apply that instrument without exception. So if that is the understanding, then the executive, the judiciary, and even the legislature, because some of the laws that have been struck down were passed by the legislature, the National Assembly and the Senate. So we have gotten a new constitution. Change has come. The cheese has moved, but the mice that is around the cheese have not realized what happened. So symptomatically what's happening in the government is that a lot of the technical support persons have not appreciated the magnitude of the changes that have been visited on us by the new constitution, and for that reason they must be held back to account, held back to audit themselves, and to be in compliance, because the alternative is not there. Just comply, check against every provision, and be sure that if this went to court, would it be struck down or not? But do not act in defiance or in ignorance or in total disregard of what would happen should the issue be challenged in court.
But Martin, when you say that you don't think the government goes out of its way to break the law, yet ruling after ruling after ruling, the court insists that there was no form of compliance, shouldn't they have learned this somewhere along the way?
I think that the government also has ears and it has eyes. If it's not listening to the judicial pronouncements, then we wonder whether they have ears. But we believe they have ears. They have heard it. It's about process, it's about Article 10 of the Constitution, it's about, now of course we've been told about basic structure. We've been told that there are certain things you can touch, certain things you can't touch. It is time for government to to question itself, to have a meeting with itself and decide one way or the other what it needs to change on. But it cannot keep on doing the same thing over and over and meeting with a judiciary that's emboldened, that is faulting it all along. So they need to listen.
Duncan, this has triggered a lot of scrutiny on the Office of the Attorney General and the Attorney General himself, Kihara Kariuki, on what then he does as the principal legal advisor to the government.
Indeed, Akisa, in these particular losses, for lack of a better word, in terms of the court decisions, is something that should actually prick the conscience of anyone in government, and more so even us, even as citizens, because there is a mechanism encompassed in the Constitution to also ensure that even if you do not have a president, a deputy president, or even ministers or cabinet secretaries currently as they are referred to, who are not lawyers, at least they have the backing of a legal entity in the office of the Attorney General, as also encompassing the office of the Solicitor General. So that it is akin to every company, even this particular company where we are in, you have obviously a legal department. Others call it legal and compliance department. So that you are expected to at least verify whether certain positions, certain aspects that you are taking meet the bare minimum constitutional thresholds. It is actually expected more of now government to actually utilize, because the Office of the Attorney General is actually being supported by the taxpayer. So that it is actually a shame that the taxpayer funds such an office for purposes of ensuring that they principally advise government and give them sound legal advice. The problem that I have is if every time your lawyer, because this is like the government lawyer, gives you advice that every now and then the court is actually disagreeing, and you still continue the same, it means the problem is not even with the lawyer, it's with yourself. So already there is a fundamental issue. But looking at what I can say may have brought us here, and I do agree with Martin, is the fact that we brought upon ourselves a constitution that we tried to make it so perfect a constitution, to a point that we were not ready for that constitution. I can tell you, even the moves or the efforts to try and bring in the BBI, if you look at all those, it is trying to pluck away what people thought was actually good. The fact that you can now, you should have been able to appoint now cabinet secretaries from the politicians. It's something that was there, was removed, but now we are trying again to
bring it back.
It is because we thought, we actually did not look at it, or ideally we are a bit lazy to now try to upgrade ourselves to now be in compliance. So you find that previously, before the 2010 constitution, there were declarations of unconstitutionality, but they were not that many.
As many as what we're seeing.
Post 2013, the administration now started being guided by the constitution proper. And ideally, every now and then, they are not alive to the fact that we are being guided by this new constitution. So it is not, it does not worry me or amaze me or surprise me when we have decisions now and then trying to indicate that they are not living up to the expected standards of the constitution. The problem that now I have, and I still belabor that, is we need then to change. Because if we don't change, we will still have such decisions. It is shameful to the government, but more importantly, it tells you that the government itself is not respecting the constitution, and it should be an example to the common mwananchi. It becomes even worse when you have decisions like the one we have for the Kenya Meat Commission.
Yeah.
A
Actually,
declaration.
got to add that in. Yes.
Yes, we should even. There are so many you cannot finish, and even tomorrow, next week, others will come because they have not changed. So that even one like that one, it is there is a declaration, but instead of the government being advised by that, they decide that we will actually ignore. We'll now leave. Our position is to ignore these court decisions. Then you become. It's actually a state that is not respectful to law. The rule of law fails. It then becomes the rule of the jungle. And that is the problem that we will face if we do not now change. Because the issue is, we cannot say it is so normal that we are now okay with every now and then a decision invalidating presidential positions.
In fact, it's become a norm now.
It's a norm now that it does not surprise even a child. But it should be something that even one decision, whenever you get even a decision disagreeing with a presidential position or the executive position, it should be so rare that that alone will call for a crisis meeting. There's something that is so wrong, because we should be the ones who lifted the Bible, indicated that this same and they lifted the Bible, and they swore to actually uphold the tenets of the constitution, which gave them the mandate to actually be in office. So if you cannot uphold that, it is something that even our institutions themselves, that is the legislature, they have been empowered to actually come in at this particular point and at least do something. The problem we are seeing is that they are joining the bandwagon to maybe castigate the judiciary, maybe
this legislative arm has most recently have been largely seen as an extension to the executive. So what would you expect?
And that is now where the failure comes in, because the constitutional design and architecture was to ensure that even the president himself can actually be subservient to now this particular legislature. So that even on such particular issues, especially when you are living outside the mandate of the constitution itself, the legislature has a mechanism. But even the legislature that we are talking about today, also we were not so ready. It is already, as we speak, the former Chief Justice Emeritus Maraga already said this is an organ for dissolution. So even the way they are sitting today, they are not in compliance with the Constitution. So it is actually running amok, and they do not have the moral authority to even lecture now the executive on this. So it's failure on both sides, all sides.
The principle of checks and balances really in this constitution seems to be the biggest headache here. And Martin, I'll bring you in at this point. Something very critical that Duncan has said, that when you have a lawyer and the counsel he gives you constantly is quashed by the courts, then maybe at some point you start to think the problem is not the lawyer. Would you agree with that sentiment?
Now, I think that we do have an experience in this country, and Amos Wako was a very long-serving Attorney General, and if you go in the back room, you'll realize that the smiling Wako did give very solid advice to the government during his time, and you cannot fault him. So the jury is yet to be out on the current Attorney General, because we don't know what kind of advice he gives and whether it is overridden or whether he does not give any at all. But at the end of the day, the buck stops with the executive, because when you fault a decision of the executive that has been passed by the legislature, it is now an extremely precarious situation. Precarious situation because you will realize that even the judiciary itself has run foul sometimes to the new constitution. For example, there was a time the previous CJ tried to discipline a judge, and the JSC was taken to court. So what we are dealing with here is that we are all learning on how to live with a new constitution. The first thing is we have new wine in the name of the constitution, but we have old skins. These old skins have failed to learn. The forest remains the same. We see monkeys come in and go. So the symptoms that we are seeing have to call us to question, including some of the provisions of BBI, in terms of their being blind to the constitutional requirements, are symptomatic that we have a new constitution that many of us do not understand. And maybe we should call ourselves to a retreat as a country, perhaps fault ourselves for passing a constitution we do not understand, and learn to understand it and then live by it. Because what we are seeing, whether in the county assemblies, whether in the National Assembly, whether in the Senate, whether in the executive, is very symptomatic that we do not understand the nature of our constitution, and therefore we are struggling to comply.
I'll ask you both this question, and I'll start with you, Martin. Do you see a dysfunctional or a dysfunctionality between the executive and the office of the Attorney General? Is that what you're reading into this?
I have no evidence to suggest that, but there are questions that I can ask. I don't know whether it's dysfunctional. I don't know whether he's living up to its expectations. It cannot be seen on the face of it. However, if what has been annulled, if what has been found to be faulted by the judiciary, have had the eyes and have had the input from the Attorney General. Remember, the Attorney General is not alone. The Solicitor General too is a lawyer, and the Attorney General is a member of the executive, and between them they have a coterie of legal counsel, and that they should actually be providing inputs. And remember that even some of these offices, including the executive, does have some lawyers as well. What we are witnessing is perhaps one section, and it could be perhaps the executive running away with the ideas that have not been given input by the Attorney General, or the Attorney General may not be at the point at which decisions are being made. So, in a sense, I could agree, there could be a dysfunctional, there could be a message that is coming to us that all is not well, but I would be very restrained to pass such a strong judgment that it's dysfunctional.
Duncan, what do you think? Dysfunctionality, do you see it?
You see, as much as Martin, and he's always very modest and will not want to be controversial, and I think that's where the courts have now gone a step further. They are not as modest as that. So it's good that we call a spade a spade. There is a lot of dysfunctionality, and it's visible. It's so visible that you don't need anyone to tell you. The rulings themselves, the decisions speak for themselves. A typical example where I tried to harmonize this, and I couldn't, and I think Martin knows better, is when there was a decision by the JSC in terms of dealing, having an interview for judgeship positions. They actually had those names, and the president was supposed to actually just ceremoniously appoint. He refused to appoint. Indeed, the Attorney General is a member of the JSC, so that collectively that was their decision, and it never came out at any point to even disagree. Then, when it means the president disagreeing with now the decision of the JSC and the constitutional provisions in terms of the role of the JSC and the role of the president. The president himself is not a lawyer, has never gone to any law school. He ought to have gotten sound advice from the Attorney General. The advice that we expect from the Attorney General to the President should be in tandem with what the Constitution says, and I believe any lawyer would actually not have any issue with what the provisions of the Constitution on that, but more importantly, with the position that the JSC took, that we have, these are the names, and you ought to now ceremoniously just appoint. All we saw was now the President moving away. As an Attorney General, if you have partaken in such a process, principally you have abided by this, and you know that the law is clear on this, and the President decides to disobey, or the executive or whoever else will be advising, it is incumbent upon you to resign, to say that then my role here is not being appreciated. Then we will actually say the Attorney General is actually giving this kind of advice to the executive, to the President, to the Deputy President. However, he has reached a point where his position is not being appreciated, and thus he resigns. Today we will be saying that the courts are actually nullifying most of these decisions because the executive is not listening to their chief legal advisor. However, and contrary to that, the Attorney General is the one who goes to court, and they actually now support the President's position in court. Yes. Yet you are actually sitting in that particular JSC. Collegiality principles apply, but you are the one representing now the President in opposing that decision. You cannot have both ways. It sends a bit of shockwaves when such a position abounds in public. Then people will ask, then where is the President getting his advice? Then it means that there is already a problem. And it is clear, and it has reverberated in many of these particular matters. If it's BBI you talk about, if it is about this issue of Huduma number, these are issues, and the beauty about it, the Attorney General participates in these particular matters. And the Attorney General has room to research. And you know, at a point you can even consent in court on certain aspects early enough, and say that I have seen that there is this particular point, we think it is actually a good point. And you are not fighting, because everyone wants compliance and the best for the country. They will actually go back to the drawing board at the initial stages and correct such processes, as opposed to rushing, and then the projects are actually, or these particular processes are declared unconstitutional, having gobbled millions and millions, if not billions, of Kenyan taxpayers' money, which would have been put into better use. But now if you have to reverse all the processes and no one is taking blame, and you see that's why even in the Court of Appeal and even now in the Supreme Court, there is still that issue of who will bear this cost. It is a very important aspect, because we cannot have processes where they expend government taxpayers' money in their millions and billions, then a process that you very well know is flawed, and you do not take any remedial action, and then people lose these amounts of money, then you'll come and tell us we'll go back and start afresh. Again, after wasting, the tender again. You know, and no one is taking the blame on this. We must, as a country, reach a position whereby someone must actually take the blame. And you do not need to be told that you are being sacked. It should be on you. I've seen countries where when the courts disagree with you in such, not even near the manner that the courts have disagreed, people resign. They actually say, I believe I am not actually serving or doing service, and there's a government position. It's not your house, it's not, you know. So people actually resign and say, let someone else, maybe I'm the one who is seeing it differently. Maybe I'm the one whose position will never be in consonance with the judges. Let someone else, because it's about national duty, let someone else come and try, and let's see if they'll give a different kind of advice. But if you retain the same people, it means there's already a problem, and the courts must now move to the next level and now ensure that people are held accountable for the amounts that are lost through such processes.
Okay, I'll let Martin react on that, then we take a look at what some of our viewers are saying on Twitter as they contribute to this subject. Martin, that then if the Attorney General feels that he is giving good counsel, but constantly, if at all this is what's happening, they're going against his counsel, why not simply just hang the boots and say, I'm not doing this?
You know, Akisa, you and Felix seem to be living in another country. In this country, people do not resign on the basis of conscience. Duncan, sorry. Yeah. In this case, in this country, people don't resign on the basis of conscience. They don't get pricked, and they don't take responsibility. So if you are waiting for the Attorney General to tell you that he has failed, he might tell you, like one politician said, that he would rather die. So that said, basically, I think that we are collectively in a bad place. Collectively, because if the Attorney General missed it, the Cabinet missed it, the National Assembly, with all its legal apparatus, they have lawyers in the Assembly, the clerking, the committees, missed it until the judiciary faults it. I don't think it's right to say the Attorney General is failing. Generally, we say we are failing as executive, we are failing as a legislature, and therefore there is a symptom or is a symptomatic problem that we now need to address ourselves to. How can we fail to understand what the aims and objects of Article 10 were in the Constitution about values and principles? How do we fail? And of course we can disagree about the meaning, interpretations and so on. But certainly now, with the new, or rather with the two assertions from the Court of Appeal and the High Court, with a 7-judge bench and a 5-judge bench, there are certain things that we now need to live with. Basic structure. What does it mean? It means that the separation of powers between the executive, the judiciary, and the legislature are foundational in terms of our arrangements, and nothing should be seen to be watering that down. It also means that even the judiciary should also have certain understanding. For example, let's agree that not everything that the judiciary has faulted about the executive may also go unchallenged. For example, judiciary to go and say that by asking Badi to sit in the executive, in the cabinet, that's illegal, I think that's overreaching, because the president can invite anybody to sit in his cabinet to advise him on certain things and so on. I think that we have things to talk about, we have conversations to have, and I would not be rushy to say, look, it's the Attorney General, it is who. I think that we have demonstrated that we do have a problem, whether it's the BBI, whether it is now the Huduma number, and a number of things. There's a problem. And that problem cannot just be switched away. We need to have a conversation. That's what I'm saying. We must have a national conversation around our understanding of the Constitution and compliance. Unfortunately, we have Katiba Institute that is helping us to understand that, and maybe a few others, but we need a larger understanding to the extent that the judiciary, the legislature, and the executive can begin from one slate. Right,
and before we go on a break, let's take a look at what our viewers here are saying on our social media platforms. Tony Mushina says, rogue judiciary with judicial activism as best, and we're coming back to talk about that. You've mentioned something about overreaching, so Duncan will also be chiming in on that. Nasho Nadero says, it is now clear that the critical angle for breaking these recurrent deadlocks must pass through these mutually inclusive elements, a goal orientation and the integrity of processes. Jesse Abhishek says the government must sit and ask themselves where they're going wrong, not just doing things because they're government. We have courts to deal with things that government is not following when it comes to the law. And he continues to say that what is put in place to protect people in case their Huduma number is accessed by frauds? So that's an issue that Duncan here has also raised. And someone called Kabi says, congratulations to the Kenyan courts. You're the dreams from far that second liberators shed blood for, we are maimed like for, and injured for, and jailed for. You're living up to your Kenyan aspirations against the executive overreach. So then, two things come here, and Jim Kelly says the buck stops with the head, and that is the executive, the Attorney General. Laban Kitele says the Attorney General, and Kimawachi Juma says Uhuru Kenyatta. That, of course, responding to the question, who or what is to blame for the government's series of losses in court. Atakisa Andera at KTN News KE. Hashtag the front row. Two questions coming up right now. Is it an executive overreach? Is it a judiciary overreach? We'll come back and try to respond to some of the questions that have been raised here by some of our viewers. Keep watching. We'll be back with more.